Group 7, and this is requests as to persons by whom forensic medical examination carried out. Can I call Amendment 28 in the name of Johann Lamont in a group on its own? Johann Lamont to move and speak to Amendment 28.
Thank you very much, Presiding Officer, and may I move the amendment in my name. We all know this is an important piece of legislation for all victims of sexual violence, and we also recognise that it continues to be a crime perpetrated overwhelmingly by men on women. This legislation seeks to make practical steps, trauma-informed, to allow victims of sexual violence to take back control and have consent, following the horrific experiences where they had been denied both. For context, in relation to my consideration of this amendment, as someone with a long-term interest in this field, I sat through the Stage 1 debate, and I cannot overstate the impact it had on me. I was moved and hugely affected by the quality of the cross-party agreement, the powerful speeches and the substantial nature of the recommendations. Members of the committee spoke about the courage of survivors who had given evidence at a meeting facilitated by Rape Crisis Scotland. And it was evident that those survivors had a huge impact on members, and I have no doubt that their testimony shaped the committee's thinking and its thoughtful recommendations. This amendment seeks to give force to the recommendation agreed unanimously by the committee. It says, we consider the definition of gender could be ambiguous in the bill, which has the potential to cause distress to individuals undergoing forensic medical examination. We recommend the bill be amended to guarantee an individual's right to choose the sex of the examiner. No one spoke out against the recommendation in the debate, and a number spoke explicitly in its favour. No group or organisation spoke against the Stage 1 report or any of its recommendations when it was published in September or when it was debated on the 1st of October. So this amendment simply reflects a recommendation in a Stage 1 report thoughtfully considered. At that point, it did not seem to be problematic, and there was no evidence that the people had concerns. So to be clear, if members do not agree that women survivors of violence and rape should be able to ask for a women's examiner, then say so, and we can have that debate. But be clear, as Rape Crisis Scotland said, that is what women survivors explicitly sought. So if you do agree, we should all do what we can to make that wish real. Those who are now expressing concerns about this amendment make a number of points, and I want to address those and will of course take the opportunity to address further ones as they are raised. Firstly, the point is made that there are not enough female examiners, so the amendment is meaningless. But that is to argue that the provision is meaningless, not the wording. If the provision is meaningless, the logical position would be to argue for its deletion, instead of resisting a change in wording. And what a counsel of despair. Are we simply to give up because we currently do not have enough examiners? The survivors of abuse are not fools. Of course not. This legislation can and should drive change, translating through workforce planning and spending a real difference in provision. And is that not why we as legislators are here? Secondly, we are told there is no reason to change because the words sex and gender are interchangeable. But if they are interchangeable, why resist an amendment which uses a term defined in law? If it does not matter, why fear clarity? But of course, these terms are no longer interchangeable, as I have come to realise. And how do I know? Because in various statements, Fiona Hislop, a government minister, has said we would not conflate sex and gender. Shirley Ann Somerville, a government minister, has said we should not conflate sex and gender. Hamza Yousaf, a government minister, has said we should not conflate sex and gender. And in gender, Rape Crisis Scotland, Zero Tolerance, at various points in recent times, amongst other groups, have sought definitions of gender which are explicitly not interchangeable with the word sex, a word defined in the Equality Act of 2010. In giving people rights, in giving women victims of rape and sexual assault rights, in giving all survivors of sexual violence rights, we need to be precise. Sex is defined in law and gender is not. A right is not a right if it's unenforceable. We owe it to survivors to listen and treat them with respect. So, in summary, survivors showed great courage in shaping this bill. The committee showed great integrity in responding to their evidence and unanimously agreed the recommendation to which this simple amendment responds. There is a direct, traceable and powerful course from the survivors' testimony to our decision on this amendment here and now. And I could put it no clearer than the statement of one member of the committee who said, "I feel a sense of great responsibility, not only to speak to ensure that the bill fully serves its purpose, but also to use this platform to give voice to those who have been silenced for so long." That is our challenge now. If we applaud survivors for their courage, if we are moved by their testimony, it is our responsibility and duty to respond. It is what we are for, and I trust members will agree and vote for my amendment.